Very good morning, students. Myself, Joita Saito. I am BSc LLB from Guwahati University, and right now I am a practicing advocate in Varanasi District Court, and I am your teacher for legal reasoning in CLAT exam. So, the syllabus for legal reasoning in CLAT exams are legal maxims, legal terms, Indian constitution and criminal law, landmark judgments, tort and contract. So basically the legal maxims are also important. Legal terms are some terms which are basically used particularly in the field of law. Indian constitution, we all know about it, and landmark judgments, torts and contract. Basically we have an idea about that what the landmark judgments are. There are some judgments which made itself a landmark for the whole of the India, and it's make its law as obiter dicta, and right now it is applying in the each and every court of the India. So as regards to criminal law, so when we come to criminal law, the first word in our mind struck is IPC. So today I am going to discuss something about some points about IPC. So IPC is Indian Penal Code, Bharatiya Dand Vidhi. Okay. So IPC, what is IPC? IPC is the general law of penal provision in India. And what does penal means? Penal means for punishment. So IPC is basically made for punishment if an offense is committed by anybody. And each and every country has their own penal code, so that they can make some acts or omission punishable as per their law in their own country. Okay, so penal means in our legal term, it means an act or offense which is punishable by law. The act or omission or offense must be punishable by law. It's not something like that the person itself, the person himself is giving punishment to the person who is a wrongdoer. So that is not allowed. The law must make punishment for the act or the offense which the person has committed. So IPC also needs a procedure to run smoothly. Take without procedure, without the smoothness of the procedure, the IPC cannot itself run smoothly. So IPC also needs a procedure to run it smoothly, for its function very smoothly. So we have Criminal Procedure Code and also Evidence Act. And Criminal Procedure Code guides the IPC to follow the path in which direction the IPC will move and leads into the conviction of the person who has committed the offense. So for this, the CRPC will guide the path in which the IPC will run. Fine? Or the trial will run. How the court will run for a criminal offense which comes under the punishment under IPC, then CRPC needed to run it smoothly. It follows, the IPC follows the guidelines of the CRPC to reach its end result. And what Evidence Act do? Evidence Act guide us how to appreciate the evidence, because without evidence and nothing can be proved before the court. And evidence is the term which leads to proof. There is nothing called proof in proof kya hai? There is nothing like this. What is the evidence? What is the proof? There is nothing like this. What is the proof? The main term is what are the evidence? Evidence leads to proof, and the Evidence Act guides us how to appreciate evidence to lead it to proof, so that the conviction can be made by the IPC. Because IPC only deals with the punishment for specific offenses which are given under the IPC, right? Then three major laws of the criminal law are IPC, CRPC, and evidence. And IPC is a fully substantive law because it only provides punishment for the offences. CRPC is procedural with some of its substantive provisions, because section 125 of CRPC is somehow substantive in nature, and other provisions are also there which are substantive in nature. So we can't say CRPC is purely procedural, but CRPC is procedural law. And Evidence Act is purely adjective. There is nothing written Evidence Act in itself which is substantive in nature. Evidence Act is purely procedural law, which is also known as adjective law. So now, what are the backgrounds of IPC? Why this IPC made? Lord Macaulay drafted the IPC, right? And why it is a code? Why it is Indian Penal Code? Because code deal with multifarious subjects under one umbrella. Whereas when we are talking about acts deals with only a specific subject. That is why when you go to IPC, you find multifarious subjects. There are punishment for each and every offences which are committing inside the India and which are made punishable by the IPC. There IPC is dealing with multifarious of the subjects which are made punishable. You may find body offences, you may find property offences, you may find offences against the state, cheating, everything you will find in the IPC, because the whole of the subjects are dealing in one umbrella, under one umbrella. That is why it is a code, it is not an act. Whereas if we talk about NDPS Act, then it is specifically deals about drugs and narcotics, right? Then what is the need of the IPC? Now, need of the IPC is, see, security for life, property and liberty is the most cherished desire of a person. Every person has a quid pro quo relationship with the state. Now, what is quid pro quo relation? Quid pro quo relationship means you help me, I will also help me. You help me, I will also help you. That is the basic object of quid pro quo relation. So each and every individual, each and every person has a quid pro quo relation with the state. State protects the public at large, and the public will follow the law of the society, the law of the state, right? The state has the paramount duty to protect the life, liberty and property of each of the individual. A penal code is an instrument with which the state controls and maintains its such paramount duty to protect the life and property of the individuals. Now, what a penal code contains? A penal code specifically mentions all acts or omissions which are prohibited by law, and there is definite punishment for it. In IPC, we will find definite punishment for each and every defined offences under the IPC, right? What IPC contains? What Indian Penal Code contains? Punishments. So Indian Penal Code contains punishments for act against the state, because state is the main thing. If you don't have the state, where we are? We don't have the existence without the state. So firstly, the act against the state are made punishable. Then act against public authority, act against body of a person. IPC have murder, 376, grievous assault, hurt, and all other offences, which are offences against the body of a person. Then act against the property of a person. Such kind of offenses are also made punishable. So IPC basically contains punishment for forcefully act against the state, because state is the paramount thing. Then act against the public authority, act against body of a person, act against property of individual. Now the concept of punishment, how it came. Firstly, there is blood money. In a previous time, there is blood money. You broke one's tooth and he will compensate you. But later on, it will found that this is not working. So firstly, the concept of punishment start with retributive theory of punishment. Tooth for a tooth. Okay. Then come the punishment of preventive theory. The preventive theory of punishment comes into play, which means preventive theory means to prevent. To prevent the person so that he can't do such offenses in its life further. Then come the deterrent theory of punishment, which means exemplary, to may set an example for the other person of the society that if you done anything like this, then you will also have such punishment. So it's a punishment like beheading, then amputing of the hands, amputing of the limbs, like this. Right. Lastly comes the reformative theory of punishment, and right now we are dealing with reformative theory of punishment, where the offenders who are convicted under any of the offenses under IPC, they have the chance to reform, where the state will work so that they can reform their mind. There will be no such kind of offenses in further. Right. Now, what offense means? What is an offense? Now see, to attract punishment, there must be an offense. And there is a big difference between a crime and an offense. Crime is a genus and offense is a species. There is nothing in IPC for which defines crime and there is punishment for crime. Right? In IPC, there is punishment for only offenses. Right? Crime is a moral wrong. How? Now see, if you are in a traffic signal and a beggar comes and begged before you for food or a bread, and you didn't give a piece of bread to the beggar, and the beggar dies. Now this is not an offense. However, this may be a moral wrong. It may be a crime. This is not an offense. Now what is offense? Offense is nowhere defined in IPC. If you go to particular section 40 of the IPC, the section 40 of the IPC only tells us which offenses are punishable under this code. Right? But when you go to section 2N of CRPC and section 338 of General Clauses Act 1897, then only you can find the definition of